Good afternoon, guys. Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from New York. Today we're having our live, as promised, Tuesday night, a little bit later than usual. And today we will be discussing a very interesting topic, very useful topic for many of you, alternatives to pending asylum status, or what to do if you're stuck in forever waiting asylum process. There are millions of people like you in America waiting for their asylum interview, for the date in court. And you all guys are looking for solutions. What can I do? You started asking yourself about 5 years down the road, what can I do to improve my immigration status? And today I'm going to give you some suggestions as to what can be done. We're going to discuss 5 main options. They will not be useful for every single one of you. Just like everything else in the United States in terms of immigration, you have to qualify for them, but some will be able to qualify. So today we will be discussing what those options are, who may qualify, what to do to qualify, and of course, in the end, you guys will be asking me your questions. So please say hello. Don't forget to type where you're watching from. Say hi. Please like and share this stream. Don't forget to send hearts. Don't forget to send stars. And we are going to start. So let's say you filed for your asylum, you submitted your asylum with USCIS, perhaps by now, many years ago, and you're tired of waiting. Asylum backlog is notorious. Some people are waiting 10 years for to be called just for their interview. Your kids are grown by now. You settled in the United States, you're paying taxes, and you would like to know what is it that you can do to finally solve this situation. All right. So first, an obvious solution for many of you who have legal entry to begin with, who have parole or acquired parole afterwards, or who have entered the United States by visa, or even sometimes on a visa waiver, even though it's a separate discussion, would be adjustment of status based on the marriage or petition by your relative, and only in a situation when you can qualify as an immediate relative. You would qualify as an immediate relative only if you are a spouse of a US citizen, a parent of a US citizen who is 21, or a child of a US citizen and you are under 21. Adjustment of status. But the main thing for this procedure would be for you to show that you entered legally. Some of you will not be able to do that. Why? Because anyone can file for asylum in the United States, whether you entered on a visa or without a visa, but you can still file for asylum and qualify for it. But for adjustment of status, it's a special procedure. You must show you've been paroled or you been inspected and admitted. However, for example, you came to the United States without inspection and later you received advance parole based on that asylum pending. Maybe you had some emergency situation. You entered back to the United States using that advance parole. Now you've been paroled. Now, if you have a US citizen spouse, you will be able to adjust or should be able to adjust depending on other criteria if other qualifications are met. So that would be one obvious option. Now, will you have to withdraw your asylum case if you are filing for adjustment of status? And again, guys, this is my live stream here. I answer most commonly asked questions related to asylum and jumping from asylum to a different status. This is like a free gold mine for you, all right? When you found the leprechaun, and this is me, and you're shaking that leprechaun for gold, because today I'm sharing you for free what ordinary you would pay hundreds of dollars for to hear. So please help me out, like, share the stream, send stars, send hearts, So we're going to have more people joining the stream. So will you have to withdraw your asylum case when you filed for adjustment of status? No, you do not have to withdraw. You need to be aware that many field offices, sometimes they make a mistake. They're saying that you have to withdraw your asylum prior to us granting you adjustment of status, but this is just not the case. There is official questions answers, I believe, received by American Immigration Lawyers Association, where USCIS leadership confirmed you do not have to withdraw your asylum case. In fact, you can still pursue your asylum case even after you get a green card. So typically what I would recommend somebody to do, if you received your green card based on marriage, you send a letter to asylum office saying that you no longer want to pursue your asylum. Why go through the stress, right, of the interview and everything else if you already have legal status? But receiving legal status based on marriage does not erase your asylum claim from your immigration file history, guys. It's still there. So if immediately after you get a green card based on marriage, you pack up your baggie and travel to your home country, it will raise eyebrows and questions on your coming back and when you're going to be filing for citizenship, where you will have to disclose all the countries you visited. You may face a challenge. USCIS may think that you filed your asylum frivolously. You did not have grounds for asylum. As long as you have a very good, compelling reason to go back to that home country of yours, you may do that. Consult with your attorney. Make sure you have proper documentation why you went back to that country. So this is what's happening if you are adjusting status based on marriage or you're an immediate relative otherwise, and you have asylum pending. Another option would be for somebody who would qualify for a U visa or a T visa. U visa, everybody probably by now heard about this visa. Interestingly, it's called a visa, but you receive it in the United States. You're getting admitted into non-immigrant U visa status in the United States. This particular interesting process of admission in a non-immigrant status within the United States has its own benefits for some people, those who cannot adjust otherwise. For example, somebody who entered without inspection, somebody who is subject to permanent bar may be able to qualify for a U visa, sometimes with a waiver. U visa is for victims of a crime. Not just any crime, but qualified criminal activity listed in the rules. Such activity may include perjury, you're a victim of perjury, stalking, domestic violence, assault, violent crimes, and other similar criminal activity. But not only that, you have to have a police report and you have to show that you've been helpful for the case to be investigated. And you must present a U visa certification signed by a police representative or by a prosecutor or by a judge. I've never met a U visa certification, never encountered that was signed by a judge. Usually it will be the police or the prosecutor's office who sign those U visa certifications. But other bodies may also sign them. For example, EEOC, local employment human rights office may sign such a certification. Local office that investigates violations against children may sign such certification. Very interesting. So whenever something negative happens to you, there is a labor dispute, or there is a domestic violence situation, there is a custody battle and your partner showed to be abusive towards children, consult with an immigration attorney as well. If you don't have status, you may be able to receive status. It takes forever, but sometimes it's a safety net, especially for those whose asylum cases were weak to begin with or got weaker just because you're waiting for a decade for your interview and your country conditions changed. So U visa or T visa. T visa is for victims of human trafficking. It takes significantly less time to receive that type of visa than a U visa. You'll be surprised who may qualify as a T visa beneficiary, person who is subject to severe labor violations may get a T visa. Not necessarily somebody who was physically brought in through the border, very important. So T visa, U visa, options. Options maybe. Those of you who may qualify for TPS, you guys are in the best position because not only you can qualify for TPS, which will go parallel with your asylum pending status, but also you may qualify for TPS special travel document. I wouldn't even call it advanced parole. It's a special travel document that allows you to travel to any country you want. Well, hopefully you're not going to go again to your home country, but upon returning back to the United States, you are admitted in lawful non-immigrant status, which is a gold mine. Now you can adjust status based on employment petition. This is your chance to jump from asylum pending to TPS, coming back to employment opportunity to adjust based on employment petition. Employment petition includes EB1, self-petition, especially for those of you who are talented business people. It may be very useful. EB2, national interest waiver, for those of you who hold advanced degree, right? And are well positioned to advance certain area of United States economy. EB2, regular petition. If you're a skilled worker, EB3, unskilled worker. Different varieties of employment-based petitions become available for you to be used in the United States if you traveled on TPS and came back. Again, extremely useful information, guys. Extremely useful information. Many people are confused about this process. They read online articles and they believe that if they filed asylum before they fell out of status upon their arrival to the United States, and now they have an employer, they will be able to adjust status, securing exception to the general prohibition on adjustment of status in employment category if you fell out of status. This is not the case in New York, okay? I personally never encountered such a case where it will be allowed. There are 2 unpublished Board of Immigration Appeals cases which are not precedential, meaning that USCIS does not have to follow them. And in New York, USCIS does not follow them. I've heard some attorneys on attorneys forum stated that it worked for them. Show me the decision. Show me the case. Maybe it did for you somehow. You convinced USCIS that this is the case. But in New York, it doesn't work. I can tell you with confidence. It will not work. So I wouldn't count on this online forum advice. There are exceptions, of course, very narrow exceptions. Typically, USCIS stays away from them unless Board of Immigration Appeals, so a federal court in your state, federal court above your state, stated otherwise, stated that they must comply if you reside within a certain federal circuit. So for me, the only way I would take the case if I have a clear, sure path for somebody to adjust status. TPS travel document. Travel allows you to do that. Next, SIJS, special immigrant juvenile status, not for everyone, but of course only for children who are under 21. If you are in your asylum case with your child who is under 21 years old, the other parent is abusive or was abusive, abandoned the child, neglected the child, disappeared, maybe passed away. Such a child may receive green card. It's called special immigrant juvenile status. Right now, because of the litigation, it takes a long time for the child to actually secure the green card, but the basis for the green card can be secured pretty fast. You go to family court first, you obtain family court orders, then you file I-360 petition with USCIS. After that, if petition is approved, the child may receive work permit if they desire to apply for it. The child later, currently about 4.5 years later, will be able to file for the green card. Sure path for a green card for the child. The child will, of course, become a citizen at some point if they choose to do so, but they will not be able to file for the parent, even for the parent who was a good parent. Very important to know. Many parents are overlooking this opportunity for their children. Children are missing out on being able to become green card holders in the United States. I'm constantly meeting kids who are saying, well, I'm 26 now, I was 21, my other parent never cared for me, and my mom and I stuck in this asylum application process. Mom was afraid to go for SIJS status. Somebody told her that she's gonna lose her asylum case. What a mess. This is just not the case. It's a lie. Mother will not lose her opportunity to file for asylum if the child is getting SIJS, all right? So if you're a parent with a child stuck in asylum process, you need to know about this opportunity. And number 5, VAWA, Violence Against Women Act, can be used by both men and women. No discrimination here. For those who has been through abusive relationship, usually. But interestingly enough, if you qualify for VAWA, unlike with the first option adjustment of status, you do not have to show you were paroled, inspected, or admitted. Very, very important. So these are 5 common ways somebody will be able to switch their asylum pending, if they qualify otherwise, to something else, something that opens up a path for the green card. And now, guys, if you have questions, I'll be happy to answer them. Let's see what's happening. We have our Facebook fans, we have our TikTok. Guys, don't forget to send stars and hearts. You will be able to play this video back on Facebook and on YouTube, and you will be able to carefully listen to this advice. All right, let me see. Hi, True Wisdom.